Now, I do want to focus in on the specifics of the criminal charges
Sure.
against Chud the Builder, aptly named person, because his whole shtick, as people know by now, is going up to random black people on the street who've done nothing wrong and saying the N-word to them to try to provoke a reaction.
Mhm.
And then he was involved in these, alleged criminal activities, like walking out on the restaurant bill, allegedly, and now he's got this attempted homicide charge. We'll come to each of these in turn, but first, I see some people describing him or his case as some kind of like a free speech issue. I don't really see it that way. Do you?
That's comical to me when they talk about free speech issue. First of all, none of the criminal charges, both for the restaurant, the theft of services, disorderly conduct, resisting arrest, or the other charges in Clarksville for attempted homicide, possession of a weapon, aggravated assault, none of those involve freedom of speech. So the First Amendment is only really meant to protect you from the government, right? That's what the First Amendment is there for. It's not intended to give you unlimited ability to harass the general public and other private individuals. So that's one of the limitations I think that people miss out on is the fact that the First Amendment is really there to protect you from the government impinging on your rights. You do not have unlimited rights to harass people or defame people. If you were to commit defamation, you are liable for that. If you were to harass somebody, engage in some form of what is criminal harassment, that's not okay. So speech is not unlimited. That's a myth, and it's a framing that's unfair to what his conduct is, because his conduct is in no way expanding free speech. This isn't some sort of college debate. This isn't sort of engaging with influencers or doing what you're doing, right? Having conversations where both of people consent to the conversation and you can have a debate, you can argue about something. If you wanted to have an academic discussion on the use of the N-word with another influencer and debate that on the internet, right?
Sure.
That's a lot different. That's a whole different scenario than a random bystander on the street that you are trying to provoke for rage bait. That's the primary content of nuisance streamers, right?
And
That's
he's
how
also
they get
not
nuisance.
actually being charged for saying the N-word, right?
No.
As disgusting as it is, he is allowed to say the N-word in public. That's not
Correct.
illegal in America.
Correct. Just like with Johnny Somali, who wasn't charged for, anything involving the comfort woman statute there, which is the most controversial thing. Many of these people, their most controversial things, they're not actually charged for. They're charged for an actual crime. So people trying to move that 8 ball are really ignoring the criminal elements here, and they're really not able to assess the law fairly. So what I say to start out with people is to calm down, put your feelings aside, and let's actually talk about the law here if you want to know how this case is actually going to come out.
Yeah, and we should talk about obviously the incident where he had a firearm. He had this incident with somebody outside of a courthouse. The arrest warrant, the local reporting suggests that Chud the Builder actually drew his gun and initiated the kind of escalation here. But his supporters are claiming self-defense. You went
Mhm.
through on your channel, and I'll link to your channel, of course, that everyone should check it out. But you went through the elements of self-defense here, and you came down with a pretty skeptical analysis of whether that looks likely to succeed, right? Can you kind of briefly talk us through that?
Sure, yeah, you have to go through all the elements of self-defense. Now, self-defense is what we call a affirmative defense. So the risky part about an affirmative defense is you have to say, "I did that." So you are
Hmm.
admitting to the crime. So, if if that defense does not work, you are guilty. There is no You've already confessed to the fact that you did the thing. So they can get you on that charge. Now, ultimately, whether they get him on attempted homicide or get him on the aggravated assault, right? He may, get convicted on one of those versus the other, even if the self-defense fails. So just because self-defense fails doesn't mean that he gets convicted on all the charges necessarily, right? But self-defense is as affirmative defense. They have a stand your ground law. And there's several elements, such as lawful presence, lawful conduct. Are you allowed to be in that place? Are you not committing a crime? And we'll give those to Chud that at the time he was allowed to be at the courthouse. He was not breaking into somebody's house. He was,
Yeah,
allowed to
it's
be
in
there.
public.
But then you get into things like, like, for example, reasonableness, right? the reasonableness of the behavior in terms of was he in a reasonable fear. Now, that's subjective to him, so it's from his perspective, but it has to be objectively reasonable. And one of the problems with that is for a normal normie jury looking at this, for these are not people that are on the internet chronically. These are not people that are Chud stands that are out there supporting him. And by the way, this jury, even if it's conservative, may have a couple black members on the jury, right? And
I'm sure
will
they're gonna love him.
yeah, I'm sure. Yeah, exactly. Like, so they'll maybe there's a couple black members, but even if they're all a bunch of conservatives, they're not going to be diehard internet people. So I think that's a very important thing he needs to consider. And when you look at that, I think most normal people looking at Chud's behavior are going to say, is this objectively reasonable? And that's going to be a hard line for them to cross. The other thing is proportionality. So he responded with a gunshot, which is deadly force. Typically, you cannot respond to non deadly force with deadly force. So there's going to be a lot of analysis on what exactly went down. Was the punch qualifying as deadly force? Now, for a punch to qualify as deadly force, it would have to be a severe punch like a head blow or something like that. So we're going to need a fact pattern to play out that looks favorable to him responding, thinking that this could kill him, that this man could kill him, or that he had reasonable belief that this man had a weapon or was pulling a weapon on him, and therefore he responded in that way. The other thing is you cannot be the initial aggressor. You cannot essentially provoke the interaction. This one is particularly dangerous. And this is the one that people try to conflate with free speech, but this is separate. This is about self-defense law, right? In order to gain access to this defense, you cannot have provoked the fight. Essentially, with self-defense, we
Even
don't want
verbally, though, I guess clear that up for us. Does a verbal
a
provocation
a
count?
verbal provocation can count. Now, this is on a case by case basis, which is why we have to see more evidence. We have to see how it plays out, right? But it's very possible that the jury could rule him calling someone the N-word as a provocation, as provoking a fight. They could look at that and say, you know what? Because he used that language, this does not apply. Right? This defense doesn't apply. Now, a lot of people say this means that the other person would get away with violence. Well, not necessarily. Both of them could be charged, right? So there's many use of force cases where both individuals are charged in that case. So they both could be responsible. It doesn't necessarily make one off the hook here. So
And to what extent does his intent matter here? Because we do have these past statements that are really horrifying. He's on clips,
Mhm.
clips of him from talking about this, but also past tweets. I'm going to read this, but it's actually genuinely horrifying. He just a couple weeks ago put on Twitter, the series finale is a dead on the pavement, referring to a black person, and you monkeys rioting when I walk free. Stay tuned. So to me, it suggests that he has this statement, and you could tell us whether this is legally relevant. It seems relevant to my moral judgment of this person, certainly. But it seems that he went out there looking to potentially instigate a situation where he could then kill someone. Is that relevant to the law here, though?
Absolutely. His history of confrontations and his live streaming and his tweets are absolutely going to come up as evidence. Now, it will be even more damning if he has to testify as a witness. And the thing is, in most self defense cases like Kyle Rittenhouse, which is one of the first big cases I covered on YouTube, oftentimes it is very beneficial for that person to get up there on the stand and testify in a self defense case. So if we have him coming up there, there's a lot of evidence as to his character that can come in, the character evidence, and all of this stuff is going to come in. All these tweets are going to come in, certainly the one that you read. And I think when a jury of normal people, total normies, right, not internet people, hears that language, they're going to
Mhm.
think that's extreme. I think that most people would think that language in the United States is extreme. So that can go towards formulating that. Now it's up to the jury to decide whether they feel it's that way or not. Some of my law tuber colleagues have said they don't think that. They think it'll be very difficult to get the requisite intent for attempted homicide. I think it's possible, right? It is possible. I certainly think that amongst the charges that he's charged with, I think they can get him on at least one of them, right? So, he's got multiple charges. I think it's at least possible to find the requisite intent for one, and I think that goes towards it.
Well, I would love to see that because I think we need to send a message against this type of behavior and these people who are
Mhm.
trying to enrich themselves at the public expense, offering
Yes.
no value to society other than just menacing people. I want to get your thoughts on another legal aspect to this, though, because I have been perusing the depths of hell known as Twitter, where people, a certain crowd of, at times, very openly racist influencer has been defending this person. And one of the arguments that they make is they'll pull up, essentially, it's like a two-tiered justice kind of argument. They'll pull up another case where a black man shot and killed someone, or shot someone, or somewhat similar incident. Thankfully, no one died in this incident. But
Mhm.
and then maybe it's in the same state, but a different courthouse or different court district, and they'll be like, the bond was only $250,000 for this, and Chud the Builder got $1.25 million. This is a penalty against whites. This is two-tier justice. They get away with this, but and they start doing this kind of demagoguery thing. Now, oftentimes they're making apples to oranges comparisons in a
Correct.
number of ways, but you also spoke about the fact that he was already on bond, right? And that comes from the first charge. That comes into effect here, right? Can you explain that for people?
Yeah, correct. And two things can be true. You can say that there are activist judges that are a problem in the United States. There are people that should not be released. I think in the case of the famous case of Irina Zarutska, I would very much agree that that person should have not been released multiple times. So that can be a problem. This thing can be true. But also we can say that Chud the Builder's bond, given his factual circumstance, his specific facts, is actually within the range of reasonableness. As a person who was already out on bond for the Nashville incident, which was just recently, so this was just a few days ago, and then coming into another incident, this shows a pattern of behavior. And when you especially look at this through the nuisance streamer framework, with nuisance streamers who go out and create a pattern of escalating events, the judge is required to think about community threat. So they're required to think, what is the risk they're going to go out there and do other things or end up in other criminal situations? And with
Seems
Chud,
pretty high.
yes, exactly. With Chud, it's very high. It's extremely high. It's essentially his MO. He's getting himself into these situations just days apart. So when you look at Chud, you have to say, no, this is very much a thing. And they can't look at the fact that he was live streaming and monetizing it for profit. And I think that is a fair factor. Most of these people that they're trying to compare it to were not live streaming, monetizing. They didn't have communities throwing up, $200,000 of support in a few days, as he had on his Give, Send, Go. So clearly he has the capacity, Chud has the capacity to bring in a lot of money and monetize this, which is an incentive for him to go out and continue that behavior if released. So I think the judge was not completely off base here. That said, do I think some of those cases that people bring up on Twitter are unfair and they should be given higher bonds? Yes, I do, right? But I can think both of those things at the same time. I can hold both of those thoughts at the same time.
Yeah, if anything, that would be a good reason to have not let those people get off relatively easy, not to let this guy get off easy.
Correct.
And he would. And I also, I don't know. I don't really believe he's getting special treatment because he's white and these other defendants were black. That seems pretty unlikely to me.
It's preposterous. It's pretty preposterous. I think given the factual scenario, you're not going to have any world in which there is outside a courthouse, multiple gunshots, where there's a crowd, there's bullets ricocheting, and the police are just going to say, and law enforcement, the judges are just going to say, oh, no, it's totally okay. You can walk free with a slap on the wrist. There's no world, and there's somebody who's shot, right? Regardless of who that person is. There's no world in which this person just walks away scot-free. And it's even worse with his tweet, where he says in that tweet, which you read, that he's just going to walk free. So clearly he's got this hubris, this ego, that he can do whatever he wants, perhaps because he thinks he's immune, perhaps because he thinks he's white. I don't know why he thinks he can get away with it. But certainly the judge, within the factors of the law, was well within his realm to issue 1.25.